Hello and welcome everyone to our new series on AI. Over the coming months, we're going to explore the key challenges and opportunities within the rapidly evolving AI landscape. Today, we'll focus on AI in the workplace, and in particular, on one specific workplace law, which is the New York City AI law. My name is Mark Goldstein. I'm a partner in Reed Smith's New York office, a member of our labor and employment group. By way of background, in December of 2021, the New York City Council passed a novel, first-of-its-kind law addressing the use of artificial intelligence, specifically automated employment decision tools, or AEDTs, as we'll refer to them today, by businesses to make employment decisions. The law, which has potential to seismically change how employers approach employment decisions, essentially bars businesses from using automated employment decision tools, again, AEDTs, when making such decisions unless several criteria are first satisfied, including that the tool at issue has undergone an independent bias audit. After many delays, city regulators began enforcing the law last July. So what does the law say? Essentially, it says that employers in New York City are prohibited from using AEDTs to screen job candidates or employees when making employment decisions unless three criteria are satisfied. First, the AEDT must have been subjected to an independent bias audit within the year prior to such use. A summary of the most recent bias audit results, as well as the distribution date of the tool to which the audit applies, has been made publicly available on the business's website prior to the use of the tool. And the employer provides written notice regarding the use of the tool to any job candidates or employees being subject to the screening. If any one or more of these three criteria is not satisfied, then an employer's use of the AEDT with respect to employment decisions would constitute an unlawful employment practice under the New York City human rights law, which is one of the country's most employee-friendly anti-discrimination laws. So how does the law define AEDT, automated employment decision tool? Well, there's a very detailed definition contained in the law and then subsequent regulatory guidance issued by the city. But essentially, it's any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation that's used to substantially assist or replace discretionary decision-making. Now, notably excluded from the definition of AEDT are tools that do not automate, support, substantially assist, or replace discretionary decision-making processes, and that do not impact natural persons, which could be junk email filter, firewall, antivirus software, calculator, spreadsheet, database, or certain data sets. Now, as noted earlier, the law frequently uses the term employment decision, the broad term employment decision. And what does that mean? Well, under the law, the term employment decision means to screen candidates for employment or employees for promotion. So noting that this law applies to both new hires or prospective hires and also to existing employees within New York City. In other words, an employment decision is a decision that helps a business decide whether to hire, fire, promote a potential or current employee. Based on the final regulatory rule issued by a city government agency, it appears the law applies to employment decisions that can be based, one, solely on an AEDT's output, two, on multiple factors, but with the AEDT's output outweighing the other factors, or thirdly, on the AEDT's output outline overruling the other factors, including human decision-making. As I mentioned at the beginning, the New York City AI law requires that notice be provided prior to the use of the tool, again, whether it's being used with regard to job candidates or existing employees. So what sort of notice needs to be provided? The notice needs to say that an AEDT will be used in connection with the assessment or evaluation of the employee or candidate if they reside within the city, that the job candidate can request an alternate selection process or accommodation, and the job qualifications and characteristics that the AEDT will use in assessing the job candidate or the employee. And this notice can be provided in a few different ways, but generally speaking needs to be provided at least 10 business days before using the AEDT. And some of the ways that it can be provided include by putting the notice on the employment section of the business's website, providing it in the job posting itself, or giving it electronically or physically to the job candidate. I mentioned at the outset that the law requires that an independent bias audit be conducted at least annually with regard to any AEDT. So what is a bias audit? There's a lot been written on this and including by the regulatory guidance from the city, but essentially a bias audit is an impartial evaluation by an independent auditor. An impartial review by a third party looking for potential biases that could be involved in or could impact an employment decision. This could include, biases, but does this include biases such as race, ethnicity, gender, and/or intersectionality? The final rule that was issued by the city, the final regulatory rule issued by the city, sets forth the following minimum requirements for a bias audit. There has to be a calculation of the selection rate for each race and ethnicity and sex category, a comparison of the selection rates to the most selected category to determine the impact ratio, and identification of the number of individuals assessed who are not included because they fall within an unknown category. What data should be used to conduct a bias audit? Well, as mentioned, the law provides a very general, broad definition of what constitutes a bias audit. However, the law doesn't set forth any specific steps or measures that have to be taken to complete the bias audit, including with respect to data used in conducting audit. That said, the final rule implemented by the city requires the use of historical data to conduct a bias audit. And historical data is defined as data collected during an employer or employment agency's use of an AEDT to assess candidates for employment or employees for purposes of promotion. So an employer or employment agency can also use historical data in related circumstances. One of the questions we frequently get from our clients is, which employers specifically are impacted by the law? Are they impacted employers with employees with job candidates or actual employees who reside in the city, who work in the city, who are applying for a job outside the city, but where a manager may be based in New York City? And the city agency that enforces the law has not specifically addressed this issue, but says that at a minimum, the law applies to employers located in New York City that use an AEDT to hire or promote a New York City resident for jobs that are located in the Big Apple. Beyond that, New York City regulators tend to take a very broad view as to the scope of New York City anti-discrimination statutes and the scope of the New York City human rights law, of which the AI law is a part. So if the job candidate or the employee at issue resides in New York City, would be working in New York City, or reports to somebody based in New York City, the employer should certainly assess whether or not the AEI law is triggered. And finally, in terms of penalties for failure to comply, employers found to have violated the law could face civil penalties of up to $500 for a first violation, and each additional violation occurring on the same day as the first violation. Subsequent violations could incur a penalty between $500 and $1,500. When each day the AEDTs used in violation of law would be deemed a separate violation. Failure to provide notice would also be deemed a separate violation. Violations for which penalties will be incurred include a sale or an offer to sell an AEDT that doesn't comply with the law, and failure to provide the required notice, as I mentioned. In addition, the city agency that enforces the law can initiate in court any action or proceeding necessary to enforce or implement the law. So the big takeaway is that if you are advertising for a role in New York City, if you have existing employees in New York City, or a job candidate or an existing employee who reports to someone in New York City, and you're considering using an AEDT, bearing in mind, again, that has a broad definition, that employment decision has a broad definition under the city law, consider whether the New York City AI law is triggered and what your obligations are as a business, including to provide prior notice, to have an annual bias audit conducted, etc. Thank you for joining me today as part of our ongoing series on AI, and I look forward to speaking with you all soon.